that is a lot easier for you all, a lot less expensive, and the ability to go back into those documents and change them at any time. If you come into our law office and just change one document, it's about $400. $400 every time. And you're gonna change your documents. I mean, it looks like everybody's pretty young in here. 5 to 7 times in your lifetime. You're gonna move, you're gonna buy new cars, you might start a business. Your kids are gonna turn age 18, guess what? Guardians aren't needed anymore. Now you can make them your executors, right? And your trustees. And for those that have older children, anybody have children here from 18 to 30? 18 to 30. They need their own will too, and trust, because they're legal adults. If something happens to them, mom and dad can't control their finances, can't control their healthcare decisions. Healthcare decisions back here. He had a client. No, it was a family member who had to be sent to the hospital. And since it wasn't a major issue, they could talk to him. But if it was a major issue, they couldn't because of HIPAA laws, right? But it's scary if kids are at school, college, they get sick, they get hurt. The college will call the parents, but they can't tell them what's wrong if they're over the age of 18 without a HIPAA form. Totally against HIPAA laws, right? So for those that think that they're too young, start them off now. I tell you, you get 18 to 30-year-olds, they're way ahead of the game. I didn't even have mine until I was like 35. And remember, no subscription fees. Once you get it for them, it's theirs for life. They go through, they get married, they have kids, they're always gonna be updating it. They're gonna move. So don't just think this is something that, oh, I'll get it when I'm older. We need it now. Everybody does. So that's kind of a estate planning 101. Pretty easy, right? I wish every college course was like that. That's why we do estate plan. That's why you need it. That's why Netlaw was created. So I'll stop here and any questions? Yeah.
With the questions,
Yeah. All right.
We have assets in India.
Yeah.
So should we and can we list them?
Yeah. So the question is foreign assets. Absolutely. I would list them in the will. You want to list everything in your will. So when you pass away, your executor knows everything that you own. Now, assets in India or any other country have to follow the law of the land there, right? But what you're doing is you're just listing everything. Here's everything I have, so nothing gets missed, right? The one thing we don't want is the executor having to come back, oh, I didn't know he had this, I didn't know he had that. And then, a year later, you're still finding out assets. List everything. But I would have a will over there too, right? Because the distribution is gonna happen a lot faster.
So if your spouse and you bought the house, or you both have the business together, still do I have to take this?
Oh, absolutely, absolutely.
Even though my name is in the house with the spouse?
Yeah, here's why. If your husband, so the question is, both spouses own the house. Does she really need this? Sure, if he dies, nothing happens. You're still alive and you're still owner. What happens when you die? Right? Yeah. So it's for assets that are individually owned or jointly owned. And you can even do a joint trust on here. One trust for both spouses, so all of the assets can be dumped in there for the protection of both spouses. But if there's an asset that you have that you don't want your wife or you don't want your husband to have, you can do 2 individual trusts and put those in there and maybe give it to the kids. And that comes in handy with second marriages. But most people do a joint trust because it's easier, and I mean, let's be honest, most things go to the spouse and the kids, right? That's how everybody usually does it.
What if you have elderly parents and when you die, how can we take care of them if both of us they are just citizens but they don't have any?
Are you talking about you pass away and your parents are still alive?
They're still alive.
Who's going to take care of them?
Who's going to take care of them and the young kids? Can we put all of that in our will?
Well, we're going to put guardians in there for the young kids. Now, for the parents, hopefully they have their own will. Right? Do they live here?
They just came.
They just came to the U.S.
Like my
But they still need it. they still need it, right? But they're gonna have, yeah, if you have brothers and sisters, family members, they need to, someone's gonna step up, right? If not, then, you would want a policy that's gonna help for, putting them in a senior citizen home or something like that, that they could take care of. So that's probably a question, there's a lot that goes into that, right? But yeah, they're gonna need to make those decisions. Hopefully you have help. Yeah.
One question is, there are two kind of people over here. So one kind is like they are citizens or they have green card, right? The other category is they are here for work visa.
Right.
H1 or something. With H1, should they prepare a will?
Sure, absolutely. Everyone should prepare a will. Doesn't matter your citizenship.
Yep.
Doesn't matter. Everyone needs this.
Yeah, if you want something specifically to be written in your will, like your parents to be, like kind of what she was mentioned, taken care of in a certain way, does it have to be financially backed in order for it to be honored? Or can there be like, just general information of
Yeah,
like how you want it?
So you can put your wishes down. It's a little bit more advanced planning, because now we're talking about the care of someone that's not your kids. So it would be a little bit, that's where you would call me, and let's get connected with an attorney, and then they can do a little bit more amendments to if that's gonna be your will of specific request on parents.
Can you throw in a little bit of insight into how the execution of these documents occur?
So, yeah.
Yeah, especially you talked about this, college student with the medical thing, or perhaps even one of the parents passing away.
Right. So administration of the documents really is going to come down to your executors and your successor trustees. Here's the biggest difference between both of them. Executors are handling everything in the will. Successor trustees are handling everything in the trust, right? Their job is to make sure that everything gets distributed. Now, when it comes to your healthcare documents, when you're naming that healthcare surrogate, that person is in control. So that person's gonna be making all of if you're alive still, right? So they're gonna be taking care of mom and all of that. So they will need their healthcare surrogates created so that, someone can take care of it. But as far as if the parents pass away, that's the executor. The job falls on the executor to make sure that the assets get distributed to the beneficiaries. They're gonna make sure that the houses and everything get taken care of, everything.
Yeah, that's not the intent of my question. My intent was more about the transition time. Where is this document? Is it sitting in somebody's house? Is it with the county office? How does it work?
Once you create your documents, you're gonna get them witnessed and notarized. I would highly recommend giving a copy to your executors, your guardians, your adult kids. So when you pass away, and you're gonna have yours, keep it somewhere safe. A lockbox, a safety box at the bank, keep it somewhere safe. Because once they have those assets, they're gonna file it with the county. Your executor files your will with the county when you pass away. You can go ahead and do it now, but they're gonna do it again, just to make sure that the latest copy is on there. And then they start the process of transferring everything. But yeah, in the Netlaw plan, you have a my file section where you can actually create folders and store all of your important information in your my file section, like deeds to houses, titles to cars, pictures, videos, anything that you don't want to lose. This filing system has 100 gigabytes of data, so you can store all kinds of stuff in there, even copies of your will and trust that are signed. Just make sure that you give them signed, witnessed, and notarized copies. But transfer time, usually everything starts within about a month and a half to 2 months, because you automatically have to wait for the death certificate, and that can take 3 weeks. And then by the time that you start writing the letters to the 401k company, the insurance company, and everything like that, transaction time, I would say 2 to 3 months. That's when everything starts. And that's exactly when you're gonna start getting your creditor letters too. So it kind of evens out. Yeah.
So if we had a will and trust done online, say 15 years back in the state of California,
Yeah.
and is it worth taking that and amending that, or doing a new one for me?
Yeah, it's totally up to you. If you're gonna take it back, you have to start all over. So if you're gonna go to an attorney, you're gonna start the whole process over again. And you'll use you'll use an attorney for that. Or you can use our software, and then you can create all your documents again and not have to worry about going back and paying more money to change it if you ever move again or you have any updates.
So we used, similar to Netlaw, we had used some of the software for that,
Yeah.
we didn't use an attorney at that time.
Yeah, well, I mean, I would follow up with them and see if you can change it.
Okay.
But
If
if
not,
our bank account is on trust name, do we need to rename in Texas again, or it is still
well,
valid?
yeah, you're gonna wanna do that because, it's a different bank account, right? With
Okay, and
different,
trust-
different account number.
The description might also change.
Yeah,
Okay.
yeah, anytime you do so if you move from like California to Texas here, you're gonna have to rename your trust document, right? Very similar, it could be the and son instead of A and D, but you have to change it somehow.
Hey, Mark, it is the follow-up to this gentleman's question
Mhm.
earlier about the bank account. That if you have the beneficiary name in your bank account, you said you don't need the will, but then how bank ensures that the parents are not actually, they died and so who does that?
Death certificate. Death certificate.
So you still
Yeah.
have to wait?
Yeah, so if you're a named beneficiary on a bank account, you just can't walk into the bank and say, hey, they died, I need that money, I'm the beneficiary. Yeah, you need to have that death certificate
Death
in place,
certificate.
you've gotta have your license to prove who you are. So,
And they
now,
are
I
minor.
wouldn't say don't do a will because of that, but, that's,
That's.
yeah, if they don't have a will.
You need to have the will.
Can we include that the bank accounts in the bill rather than updating the beneficiary on a regular
Yeah,
basis?
yeah, if you wanna just put it in the will instead of the bank, that's fine too. Just have it named somewhere. Cause if you don't have it named anywhere, it's gonna go through probate.
So we did a will here, using another software, we have it, will document. How easy is it to transfer it to this one will?
You wouldn't transfer it, you would start over.
Oh.
So you have to start over, right? It's like going from one attorney to another. They're not gonna take the other attorney's documents. Same with us. And here's why, because you wanna start over, because you may have things that have changed. So you're gonna start over, and if that wasn't a pour over will, we have a pour over will into the trust. So all of those assets will automatically pour over into the trust when you pass away. So that'll protect, when you file, those assets will be private, not public.
How does this compare to other, software like Rocketlaw?
Yeah.
Because do we have, access to attorneys who will validate our documents?
Yeah, we can do a review for you. Personally, probably the first attempt wouldn't be with an attorney, it'll be with somebody that I trained. But they know everything that you're gonna ask. They've answered these questions from attorneys 1,000 times. So I would probably have someone like that do it. If you need an attorney, yes, I can refer you to one. And you can talk to an attorney in Texas.
Is there an added charge with it? Is it-
Usually a consultation probably wouldn't be,
Yeah.
but if they do any work, absolutely.
Okay.
Absolutely. Let's go ahead.
If we add an asset to a living trust, we need to go back to the county and amend the trust, nothing?
Well, you don't
Like
have
we
to
can add
amend
a
the
house.
trust, no, you would just transfer that asset into the name of the trust. That's all you have to do. Yeah. Yeah. You don't wanna file the trust with the county, because trust is a private document. You file it with them, you just made it public. Just the will, just the will.
So question about the trust, property being transferred onto the trust, can I still sell it?
Sure, sure.
So the
Yeah.
trust sells it or I sell it?
Trust would sell it, but it's a revocable trust, so there's no tax consequences or anything like that.
So the
Now,
$260,000
Yeah.
that rebate which I get, I can still get it?
Yeah, but, I'm gonna put a big but on this. It depends on if you still have a mortgage, they may have you take it out of the trust name and put it into yours to sell it, so that they can transfer that money, out of the loan. You have to be careful with that. So, if you're gonna sell it, talk to your mortgage company first and say, I'm gonna sell this house. I have it in my trust, do I need to take it out? Your loan officer will have that conversation with them.
So usually you have to, you have to take it out. I did the refinance and I had to take
Yeah,
out that
but
and.
refi is different than selling it.
Okay.
Do kids get taxed on inheritance? And if so, can you
Yeah,
add that money in
yeah.
your trust to ensure after you pass?
Sure, yeah, so if you're a US citizen or green card holder, there's no taxes up to 26 million for a married couple. If you're not, it's 60,000. So big difference, right? So yeah, if you're not a U.S. citizen or green card holder, I would talk to a CPA. Let's talk about tax savings. Or these guys know how to do it too. Somebody had a question. Okay, I'll work my way back. Absolutely, absolutely.
So, can you name a foreign national or either professor or a institution?
Yeah. Yeah,
And
absolutely.
that's yes,
Yeah, but
yes,
remember,
yes.
you have to name someone from your state as well, because they're gonna have to do the legwork here. They're gonna have to go to places.
Can you have like a list of executives and?
Yeah, you'll have your main executors, then you'll have your alternate executors. So there's gonna be a list inside the document.
What's the process of removing property from the trust? Is it simple as changing the document, updating the document, or?
Like you sold a property and you don't have it anymore?
Yeah.
Yeah, once you sell it, it would be out because you don't own it anymore. I would just go back and take the wording, just delete that property out of your will and trust.
And then register it to make it formal, or is there a process?
Yeah, well, I wouldn't,
Yeah.
because your executor, that's one of the rules of your executor, they have to file it when you pass. If you don't think they are, then yes, go back and file it every time there's a change. I mean, I filed my will, my brother knows to do it, he's my executor, but I went ahead and filed mine, just so I have one on file, and it was like $12. So it wasn't, it's not a big deal.
So a will becomes a publicly available information?
A will is a public document, a trust is a private document.
So,
That's how it avoids probate.
so if I know where to look for yours in Wood County, I could find.
Yeah, you could do a public search on it.
Got it, yeah.
And not anything for the families with special needs children?
Yeah, we have one document that is a la carte, is a special needs trust. It's a third-party trust, so that means that anyone can leave an asset behind for the special needs person. The reason that you want to do that is, the reason that you want to create a special needs trust is if that person is receiving federal funding like Medicaid or any kind of federal funding for being special needs, they cannot receive any asset, because the government will say, hey, you have all these assets, you don't need federal funding. But if you have a special needs trust and grandma and grandpa pass away and they want to leave something behind for their special needs grandchild, they can leave it via the special needs trust and they will still receive their federal funding because the trust is private. So if you have special needs, get with me after this. There's a lot that goes into it, and I have Jennifer in my office that is my special needs person, and she can walk y'all through anything. Somebody?
Yeah, he is. A quick question on the trust side. So assuming both the husband and wife have one trust, from a best practice perspective, does it make sense to have death benefits from insurance going to the trust?
It's gonna follow the same route because it's going to avoid probate automatically. So whether it's in the trust or not, doesn't matter. It's still gonna be distributed to the beneficiaries.
So there are no major benefits of having it go to the trust per se, a death benefit.
Anything that has named beneficiaries, not really. All right, let's clarify that. So 401k and life insurance, those are the two biggest ones. And let's throw bank account in there. They all have named beneficiaries. So at death, they will transfer automatically, no probate. But let's go back to the people that raise their hand that have underage children. And they are the beneficiaries of the 401k, the life insurance, and the bank account. Of course, they can't access that, right, because they're minors. So the guardian's gonna have control of all of that. If you put it into the trust, then you would have a trustee and a guardian. They would have to agree on what comes out for the benefit of the kids. So in that case, it might be a good idea. That way you have checks and balances. Or the guardian again will have full control over everything.
Is there protection against like lawsuits if you put your assets under a trust versus under your personal?
No, that's an asset protection trust. This is a probate avoidance. This trust is only there to make sure that the assets get distributed to your beneficiaries without going through probate. That's it. So, and that would be irrevocable trust and majorly an asset protection trust. Those have to go through attorneys.
One big question, you said that if you change the state, you have to do the will and trust again.
Yes.
So how easy or difficult it is if you use your software?
You just log back into your account. So you have a My Profile section that says who you are and where you live. So you just change it from Texas to California, and the software will update to California documents.
Then you have to take the new documents. and
Yeah, you're gonna wanna go back through the software, fill it all out again, because each state asks different questions. Right? So you'll fill it out, get everything witnessed and notarized again.
So, add on to that same question, let's say if you change the state and you go with the Netlaw, right? There's no fees involved with the insurance fees. But let's say, based on California law, if there are some changes, and if the attorneys are going to make a change to the document, will there be a fee involved?
No. So if there's any, once you all create your documents through this, if there's any state law that changes through the estate planning wording of your documents, we will update our software. And then we send you an email and a certified letter that says your power of attorney changed. If you want the latest one, log back into your account and assemble your documents, and you'll have the latest and greatest. That's free. But you do have to print it out and get it witnessed and notarized, so try to find a free notary. Banks are good. Banks are good.
You mentioned about taking the will and giving it to the county, registering with the county. Why do we need to do that? And like, what if you don't? What happens if we don't do it?
Yeah, they'll ask. So with if they don't, they're going to come. The executor's got to file this with the county because the state has to have your will on file. Because if not, then everything's going to start going through probate. So they're going to be looking for your will to say, okay, do we need to get involved, or do you already have this taken care of? So a representative would reach out to you from the state that says, hey, we see that this person passed away, assets are starting to be distributed, why is that? So, but if you file it, then they see it in the records.
Does Netlaw help with the filing portion?
No.
Is there any extra cost, like when, say, one of you passes away and then the execution part of it versus just the creation part of it? Is there a cost to having everything done once you're?
No, unless you want to pay your executor for doing everything, which is usually about 5%. That's standard at the law firm. But yeah, there shouldn't be anything to transfer our assets.
Is there a specific place other than a will to take care of the surviving spouse? That one of them who passes away.
Yeah. So the husband passed away, how are we taking care of the,
Yeah, so
well,
will that
your
be-
will, you're gonna, you'll list your bequest, leaving everything to her, and you wanna put it in the trust, and make sure that once she keeps everything, if she's on the deed of everything, or the property needs to transfer to her, if it was just in your name. Yeah. Mainly the will.
One quick question, you said that the executor should be from the same state. Is it recommendatory or mandatory?
Yeah, it's highly recommended.
Because
Yeah, now, your executor can be anybody over the age of 18 from anywhere, but at least one of those people, your successors, has to be from your state.
What's the cost of the software?
They're gonna talk about costs here in just a second. It's a secret.
So if you are using executor and successor, what's the difference between?
Yeah, so your executor handles everything in the will, your successor trustees handle everything in the trust.
Wow.
But it's usually the same person. Your executor is let's be honest, it sounds really complicated, right? But let's be honest, if we're creating this, your executor is gonna be your spouse.
Yeah.
And then any adult children or your brothers and sisters. Well, guess who your successor trustees are gonna be? Your spouse and your kids and your brothers and sisters. It's the same 5 people probably that are in every role. That's what makes it good. Because people always say, well, how do people know I died? Well, you know, it's your main people.
So would you say the executor should be one of those 5 the close family members, or is it better to find a friend or somebody else?
I mean, it's whoever, I will tell you the answer to that is whoever you think is the most responsible person that you know. That should be your executor. Yeah, because, you know, even for my parents, we've taken like dad and mom, right? They had each other as their, it's not anymore, we changed it. Now it's me and my brother, because they're in their 80s. Mom, if dad died, mom can't handle that, right? And vice versa. So that's where we come in.
All right, any more questions?
Well, I start charging.
So, wasn't it worth our every minute that we got here this morning?
Yes.
How many people you know that would benefit from this information, guys? How many people?
67%.
Everybody. Right? So, there's one action item. Today is a Super Bowl Sunday. As soon as you get out of here, then the Super Bowl parties happen, and then you're going to get together, and then suddenly Monday is going to hit, and then Monday to Friday we're going to get into that cycle, and we're going to forget about it. Who's Mark? Oh, I'm Mark. I don't know. Who's Saurabh? Who's Amit? Nobody knows. So before that thing hits, I want you to make sure is before you leave, meet with the person who invited you here. First action item is meet with the person who invited you here. Get on with one-on-one, just like Mark mentioned, like answer generic questions. If there is any one-on-one, schedule that time with you. And then we will talk about everything. And then it's very reasonable pricing. It's way cheaper than when you go to an attorney. So all of that will be discussed. Schedule that time with you. And let me ask you one more question. Like, now, do you feel empowered that you are able to manage your own estate planning? How many people you feel like? So just like you are able to manage or able to at least understand how that estate planning is done in a better way, does it make sense how to manage your own finances? Let me ask you guys, who's the best person to manage your own finances? So just like this estate planning, wouldn't it be great if you are made aware of certain powerful financial concepts? Would you be able to manage your finances better? And exactly just like this, next week we have a session on how to manage your finances, how to teach, how to learn about those powerful financial concepts that I wish I knew 10 years ago. Those things are going to be shared. But before I'm getting back to this topic, that we do handle all this Netlaw will and trust process in this office. The notarization process is totally complementary because we have notaries available in this office. So we do those notarizations, and when you get done, that one-on-one session, apart from these general sessions on about knowing your finances and those powerful financial concepts, the financial planning session, it is a high value thing, one-on-one session for each family, that is even complementary as part of this package. So avail that, and certainly what I would urge you is to take advantage of schedule that next meeting with the person who invited you, and then make sure before it gets away from our mind, let's schedule that appointment. And I would invite, and first of all, I want to thank Mark for I would like Amit to, yes.
One of the things I think we all understand, this session was not a selling session, it was a education session, and Mark does it with no cost. I mean, he has been traveling to many states and cities, and he has been doing it. So thanks to Mark. I mean, he came all the way here. And this education is, can you raise hand, can you tell this to at least one person whom you know? Who can tell at least one person, right? You, one family you definitely know. This is like, otherwise we have to do the GoFundMe for them. Instead, why not do this? Like helping them with this. This is the information they are sharing, and thanks to everybody who spent their, I mean, they came here. Again, by thanking, you expect that this is some sailing session, no? We are very happy that you are here, but you can transfer this information for others and yourself. Just get in touch, as Saurabh said, get in touch with the person who invited you, schedule that meeting, and then we can go from there. So, anything else we have?
No, we're good. See you guys next week, Saturday, just a half mile away from here. That's the financial, powerful financial concepts education session is going to be held, and I don't want to miss that. It is going to be at 10 a.m. in the morning on 15th of Saturday, 15th of February at 10 a.m. 6500 International Parkway. We will send a flyer.
Yeah.
Just
So
like
the
we sent
person
a
who
flyer for this
invited
event.
you can get in touch with that, and then they can forward that information to you.
Super guys.
Alrighty. Thank you once again.
Yeah, yeah.